In this section, we will be discussing the various parties who play a role in a title insurance transaction. Assuming that we are discussing a purchase transaction and not a refinance, the two most important parties involved in a title are the purchaser and the seller. These people are known by various interchangeable names or titles. The seller is also often called the record owner or certified owner. In the deed and the contract of sale, he is also known as the grantor and sometimes the party of the first part. All of these titles refer to the person who either owns the property or who has the right to sell it to a bona fide purchaser. But it should be noted that it is possible in certain circumstances that the seller and the record owner could be two different people. For instance, if the original owner of a house dies, the title to the property would transfer to his or her estate, which would become the record owner. But an estate isn't a person and can't sell property. The seller in this type of transaction would be the administrator or executor of the estate, because even though that individual does not own the property, he or she has the right to sell it. The seller in this type of transaction would be the administrator or executor of that estate, because even though that individual does not own the property, he or she has the right to sell it. The purchaser or buyer is also commonly referred to as the grantee and the party of the second part, in the deed and the contract of sale. This is the person who intends to purchase the house, or the person into whom the new deed will be executed. This seems obvious enough, but as always, there is potential for hidden complications. For instance, it is possible in certain circumstances for one person to be both a seller and a purchaser on a deal. This can happen in a situation where title is not being sold, but a deed is being recorded to modify ownership. For instance, if John Smith owns a piece of real estate and wants to add his wife, Mary Smith, to the deed, the transaction would list John Smith as the seller and John Smith and Mary Smith as the purchasers. Is John Smith selling or giving the property to himself? Not really, but the operation of law dictates that he be listed on the deed as a purchaser, just as if he were a new owner. New York is unique among the states in this country in the way real estate transactions are handled. In most other states, a buyer and seller enter into contract, a real estate broker orders the title insurance, and the title company not only issues policies but also acts as a settlement agent, which means that they take everyone's money and all the documents. They make sure that everyone's requirements are satisfied and that the documents are signed and recorded. And then they distribute the money to all of the correct parties. In New York, we do things a little differently. Here, the purchaser, the seller, and the bank are all represented by attorneys. Purchasers and sellers' attorneys are responsible to make sure that the client's interests are protected throughout the transaction. Bank attorneys are also responsible to represent the interests of their clients. However, the bank attorney in New York is also responsible to distribute funds according to the bank's instructions at the time of the closing, essentially playing the role of settlement agent in the deal. As a general rule, it is the purchaser's attorney who orders a title insurance on the purchaser's behalf and acts as our client. Purchaser's attorneys represent the largest segment of our client base at McGregor. However, there are circumstances under which a title might be ordered by a seller's attorney, bank attorney, or even a mortgage broker. In any event, the level of expertise that is necessary to understand the complexity of title issues is such that it is traditional in New York for a title agency to deal with the attorneys on a transaction rather than the individual purchasers and sellers in order to expedite the process. Not every transaction that we insure will have a lender. There are times when real estate will be purchased for cash and no mortgage is required. However, the majority of the transactions that take place include a mortgage of some kind, and thus require a loan policy. Lenders can be individuals, corporations, or government agencies, but the majority of mortgages are made to banks or lending institutions. When a bank or lending institution is involved in a transaction, it can make it more difficult to close the file. Banks traditionally have more stringent standards and more complex requirements for the content of title reports than underwriting policies require. For instance, many banks will not accept a survey that is more than 20 years old, will not accept a report with an effective date more than 60 or 90 days old, and require that searches run against individual purchasers include middle initials. Because banks traditionally sell mortgages on the secondary market in bulk, they will normally not allow a title to close with anything other than the standard exceptions in the Schedule B. However, even though lenders can make the title closing process more difficult, they are also a large potential source of business. As we mentioned in the previous section, the purchaser's attorney is typically the party who orders title insurance in a real estate purchase. But in a mortgage refinance transaction where no change of ownership is taking place and no new owner's policy is needed, it is not uncommon for the lender to order a title report and loan policy directly. It should be noted that lenders are not legally permitted to require the use of a specific title company. A refinancing homeowner always has the right to order a title report from a company of their choosing. However, since the property owners in these transactions are not purchasing insurance policies of their own, they will, in many cases, forego that right and allow the lender to handle that part of the transaction. Real estate brokers are often overlooked parties to the title insurance process, especially in New York, where attorneys perform many of the insurance-specific tasks that brokers are responsible for completing in other states. However, it is the broker who brings the purchaser and the seller together in the first place, and is therefore ultimately responsible for the creation of most of the transactions we insure. Brokers do not have direct decision-making power regarding which lawyers, title insurance companies, or lenders a purchaser or seller will use for a transaction. However, because of their expertise in the field of real estate, as well as the personal relationships that they form with their clients, be they sellers or buyers, brokers often find themselves in the position to recommend that their clients use specific real estate professionals. As such, they may not be able to order title insurance directly, but they do often have the influence to steer purchasers toward one company over another. This makes them a valuable source of potential business. At this point, we must differentiate between title companies and title agencies. A title company is the actual issuer of title insurance and is often referred to as the underwriter. The majority of underwriters operate on a national level and have local offices in the New York metropolitan area that specifically specialize in and handle their New York operations. A title agency, on the other hand, is an independent operation which acts as an agent for a title insurance company. The roles of the underwriter and the agent are similar in title insurance as they are in any other insurance industry. The title agency is authorized as an agent for the underwriter to take an application, run a title search, and issue a title report and policy on the underwriter's behalf. This is the role that is played by McGregor Abstract. As an agency, McGregor Abstract is responsible to search, read, clear, and close titles for our clients. We handle the file from application to closing and beyond, including recording documents and holding escrows. We issue policies for our underwriters and remit a portion of the premiums to them. It should be understood that McGregor does not actually insure titles. Instead, we issue title policies on behalf of our underwriters. McGregor Abstract represents 3 of the top national underwriters. Each underwriter has different rules and guidelines concerning raising and clearing issues. Because McGregor has more than one underwriter available, it gives us greater flexibility in issuing titles. Often, A title that one insurance company will reject due to defects can be closed using another company with different standards. The good relationships that we have with our underwriters also gives us a deep pool of resources and expertise when we are faced with unique title or legal issues on a file. The title companies that McGregor writes policies for are First American, Old Republic, and Stewart. Traditionally, the title company or agency does not do the actual examination of the back chain of a title. As we discussed in earlier chapters, the development of the industry created a subsection of specialists who complete abstracts, examinations, and other relevant searches of public records. In today's market, these individuals operate as independent contractors, and their work, while still encompassing an abstract or examination, has expanded to include a much broader spectrum of public information. The searching of public record for any form of potentially relevant information is generally referred to as a title searches. Searching is really broken up into two categories. First, there are searchers who examine and abstract the back chain of title. We call this type of search an abstract, and it is the most fundamental of title searches. Second, there are municipal searches. Municipal searches are searches for the records of the relevant municipalities, which include cities, towns, and villages, for judgments, liens, and other issues that might affect a title. These potential issues are a matter of public record, but not indexed against a specific piece of property, and include searches for bankruptcies, fire department violations, and local street information. McGregor employs several different abstractors. Each county in the area has its own unique recording system, and most of our abstractors are therefore county-specific, which is to say that they only work in one or two counties. It was mentioned earlier that New York City has its public record system available online. It is therefore possible under certain circumstances to abstract a sufficient back chain of a title online without ever leaving the office. McGregor employs title examiners who complete these searches, which we label in-house searches. An in-house search is just as thorough as a search done by an independent examiner, but is cheaper and quicker than sending it out to a third party. Municipal searches cannot be done by in-house examiners, and are therefore always assigned to independent contractors. While many municipal searches are relatively quick and easy to obtain, there are some towns and counties that take a long time to provide the required information. Certificate of occupancy searches in Oyster Bay, for example, can take over 10 weeks to be completed. As a result, we will often send out our initial title reports before we receive all of the municipal searches. However, they are a necessary component of the report and must therefore be included before a title can go to closing. When a title closes, the title agency sends a representative to the closing. This representative, called a closer, acts on behalf of the title agency and is responsible to make sure that all of the title company's stipulations are met before policies are issued. The closer's responsibilities include clearing exceptions, checking proofs of identification, creating escrow agreements, making sure that all documents are correctly executed, and calculating and collecting money on behalf of the title company, including insurance premiums, recording charges, taxes, escrow charges, departmental charges, and other fees. The closer brings his or her marked up report, the proofs that were collected, the signed original documents, and the money back to the title agency to be processed, and is responsible to make sure that the closing is handled correctly from beginning to end. To close a title requires skill, training, and an eye for detail. A closer who is incorrectly, improperly, or insufficiently trained can mishandle crucial title issues, collect incorrect amounts, or otherwise put the title company at risk. Some title agencies employ in-house closers. However, the majority of closers in New York work as independent contractors. McGregor has a long list of closers who cover closings for us, but all of our closers are screened before we begin to use them to ensure that they are able to fulfill their duties in a competent and professional manner.